So today we're going to take a deeper look at alternative dispute resolution. Do you remember from the last presentation what the three types of alternative dispute resolution are? Take a minute and think. They are negotiation, mediation, and arbitration. Do you remember what the advantages of ADR are? Confidentiality should come to mind, preserving relationships with clients and customers and suppliers. It's often less costly and less time-consuming than litigation, than going to court. And each side can usually come out with something that they can live with, whereas in litigation, only one side can win. So let's dig in a little bit and look at negotiation, mediation, and arbitration. So first, we're going to look at negotiation. It's the most common alternative dispute resolution method, and it's actually an important tool in all aspects of business, not just in the different stages of a dispute. It's a non-legal, unstructured process that's used to resolve the vast majority of legal disputes at some stage of their development. The goal with negotiation is to reach a mutually acceptable resolution. Some of the advantages of this are that they're cost-effective, they can be quick, they're customizable to the different parties' needs, and they can be used to resolve virtually any type of dispute, as long as the parties are committed to finding a mutually acceptable resolution. But we know this isn't always the case, which is why we have mediation, arbitration, and litigation, which we'll talk about. Negotiation can be used at any stage of the dispute process. So even if it doesn't work to prevent a dispute from escalating or proceeding to court, it could ultimately still be the method of resolution. For example, we know that many lawsuits are settled just before they go to court, or even during a trial or after a trial. So negotiation can be engaged at any point in the dispute resolution process. There are some exceptions in terms of when you can use negotiation. So for example, if an organization creates a toxic spill and has insurance to cover such accidents, then it's not appropriate for the organization to directly negotiate with those impacted. In such a case, the insurer has to conduct the settlement negotiations on the organization's behalf. If it is determined that negotiation is appropriate in this situation, there's really no rules as to how the negotiation takes place. It can be formal or it can be really informal. It usually starts by first determining the nature and the extent of the dispute. And so the parties look at, what is the impact of this dispute? What is the severity? Is this something that we can handle ourselves? After that, the two parties come together to discuss the dispute. And the intent here is to find a mutually acceptable solution. When negotiation is used, something called a release is often used. This is a document where one party agrees to relinquish any past, present, and future claims arising from a certain event. So for example, if you back into someone's car with your own car, and you both agree not to go through insurance because the damage is minor, one party may ask the other to sign a release so that they can't come back later and ask for more money because they claim there were more damages than they initially thought. Not all releases, though, are legally binding and should always be reviewed by a lawyer. Now we're going to move to looking at mediation. Mediation occurs when the two parties bring in a neutral third party that they both agree on to help them reach a settlement of their dispute. In mediation, the third party doesn't make a decision. They merely help the two parties to find a solution. So they can clarify the interests of the parties, they can manage the whole process, they can organize the discussions, they can clear up any misunderstandings, and ultimately, the goal is for them to help reduce the tension between the parties. Mediation is less expensive than having a judge or an arbitrator make a decision. Remember, in mediation, they don't make a decision. One of the other advantages with mediation is that they can be done privately, which protects confidentiality of the two parties. It's also seen as a cooperative process. Both parties agree to try to find a mutually acceptable resolution. Because it's less adversarial than going to court or hiring an arbitrator, the relationship between the two can be preserved as well. Remember that relationships are key to successful organizations. When it comes to the resolution, when you're using mediation, there's really no rules about what form that resolution has to take. Therefore, mediation can be easily tailored to the needs of both parties. You've probably heard of mediation for family disputes, such as divorces or custody arrangements. However, we're seeing it more and more in commercial disputes as well. I have to stress that this only works if both sides are interested in compromising, finding a mutually acceptable resolution. This usually means that both parties agree to give something up. In some jurisdictions like Ontario, mediation is actually mandated before a trial will be scheduled. This means that the two parties have to try and first resolve the dispute through mediation before it can go to court. There's really no mandatory qualifications to become a mediator. They are often lawyers or retired judges, but there are also courses that individuals can take in order to become a mediator. Anyone can become a full-time or part-time mediator. It's actually a fascinating career, as you can well imagine, based on the differences in the disputes that you'd be looking at and the types of facilitation that you would be involved in. So I find it quite fascinating. Mediation is often face-to-face. Traditionally, that's what it's been. However, it can also be done through video conference or online. As you can imagine, globalization and advances in technology allow us to do more and more mediations online. My guess is that the post-COVID world will probably see even more online mediation. It's important to remember that mediators do not make decisions. Rather, they facilitate discussions that lead to the parties resolving the dispute voluntarily. It has a very high success rate, but each side must be ready to compromise. In many contract disputes, the parties want to win because they feel they are right, and winning means they don't give anything up. If this is the case, then mediation is not going to be successful. Mediation ends with something called a settlement agreement. What a settlement agreement does is it sets out the terms of the agreement, brings closure, and it prevents future litigation. This settlement agreement is essentially a contract and can be enforced the same way as any other contract. We're going to talk about this, contract enforcement, in Module 2. Now we're going to look at another form of alternative dispute resolution. This time it's arbitration. It's different from mediation because with arbitration, a third party is actually appointed by the parties to make a decision. It usually starts with a hearing, which is relatively formal, and during the hearing, each party makes submissions. Essentially, they're presenting their case, and the arbitrator takes that information to make a final decision. That decision is usually, but not always, binding. Binding means that the parties have to comply. So arbitration looks a little bit like litigation in that the resolution is outside the control of the two parties. This is often preferable, though, to litigation because the process is still within the control of the parties, and it's less expensive and usually faster than litigation. Arbitration actually works really well for commercial disputes. Generally, you can find an arbitrator who has expertise and experience in your specific industry, so they understand the context within which they're making a decision. Arbitrations can be kept between the parties, which helps them to avoid negative publicity and damaged reputations. And arbitrations can also keep commercially sensitive information private. We'll be changing our focus to contract law in Module 2, and arbitration is quite common when it comes to disputes about contracts. Most significant commercial contracts have what's called an arbitration clause right in the contract. This clause stipulates that most disagreements between the parties will actually proceed to arbitration, so it's very common. As I've already mentioned, after the two parties have provided their arguments, presented their cases, the arbitrator renders a decision. Whether or not an appeal is allowed depends on whether the two parties agreed upon this possibility at the beginning of the process. As I've stated, whatever the arbitrator decides is usually binding, but there are some exceptions. Binding essentially means that if one of the parties doesn't comply with what the arbitrator decided, it can be enforced in court. So for an example, if an arbitrator decides that party A must pay party B a certain amount, and party A ultimately refuses, then party B can take party A to court. Just as with mediators, there are no mandatory qualifications to become an arbitrator, and there are actually courses that can be taken to become one. Many of the people who provide mediation services also provide arbitration services. There is an institution in Canada called the Alternative Dispute Resolution Institution of Canada, that's a mouthful. And this institution keeps a roster of all of these practitioners. And so if an organization is considering mediation or arbitration, they can go to the ADR Institution of Canada website and see a list of all of the practitioners that might be able to help them. Arbitration is particularly important when it comes to international transactions. Let's use an example. Let's say a widget manufacturer in Canada gets a large order for widgets from a company in Brazil. There is a written contract that says they will buy 20,000 widgets for a set price. The Canadian company then makes all of the widgets, packages them up, and ships them to Brazil as per the terms of the contract. But once there, the Brazilian company refuses delivery and states that they will not pay for the widgets. They no longer want them. Disputes like these are really complicated. Questions arise about which country's law applies, which country's courts will hear the case, and whether, even if a court does hear a case, its decisions are enforced. On top of that, there's no international court for commercial issues, and there's no international system for enforcement of resolutions, if they do find a resolution. So in these cases, arbitration is the favored form of settlement in international contracts. Most large contracts, especially international transactions, have arbitration clauses written right into them. So this is the end of Module 1, Lesson 4B. There's one more lesson in this module, and in it we will take a good look at what the litigation process looks like in Canada. Bye for now.